Welcome. In this part of the program, we're going to be discussing trial tactics and strategies, and we have three of the leading litigators in this area. They each have a unique style, and together they represent 81 years of experience. Well, I think they look quite well preserved.
Porter's got 65 of it.
Robert Armstrong QC has an LLB from the University of Toronto. He was called to the Ontario Bar in 1967. Got his Queen's Counsel in 1978. He's a partner with the firm of Torrey, Delorier and Binnington. He practices general litigation at the trial and appeal levels. He was counsel on the Dubin inquiry into drugs in sports. He's a fellow of the American College of Trial Lawyers. He's a member and director of the Advocate Society, and he represented Casey Hill in the Hill and Church of Scientology case at the Court of Appeal level, and he is also going to be acting for him in the appeal to the Supreme Court of Canada. Julian Porter QC practices litigation, and he has practiced litigation exclusively for 28 years. He's a senior partner at Porter, Poslins and Harris, and he has appeared before all levels of courts in every kind of civil and criminal proceeding. He's counsel to the College of Physicians and Surgeons, and he's well known for his work in defamation.
How much more modest that is than Mr. Armstrong's And Chief Justice Dubin, I think you and I would agree that that was improper advertising by Mr. Armstrong.
Mr. Porter has been counsel in a number of libel cases, and he's written in the area and is a co-author of the book Canadian Libel Practice, and there are a number of excerpts of that book in your materials. David Stockwood QC is a partner with the firm of Stockwood, Spies, Cragen and LeVay, and he practices in the area of civil litigation with a special interest in libel and slander work and medical misconduct. He has an LLB from the University of Toronto. He has taught civil procedure, and he is the author of articles as well as 2 legal textbooks, one on injunctions and one on civil litigation. Now, in order to get the most out of this time as possible, we've divided the area into about 6 different parts. We thought we'd first talk about the general considerations in a libel trial and tactics and strategies, and then move on to about 5 different areas of the trial: the opening statement, direct examination, objections, closing, and cross-examination. So I thought if we'd start off with the general overview, perhaps David Stockwood could introduce the topic and give some of the ideas that he has. David.
Well, I think the first thing is that you should know that all 3 of the panel members are close friends, and we propose to insult each other freely. In fact, we invite you to add to the appraisal sheet by voting for rudest panel member. If Mr. Armstrong wins, Julian and I will give up the ghost, because being insulted by Armstrong is like being savaged by a gerbil.
I knew this was a mistake.
The other thing that collectively, and Bob doesn't share in my sentiment, the first one, but collectively we'd like to say is, if some of the things we say seem fundamental, we apologize. They seem fundamental after the fact, but in our collective experience, libel trials really aren't lost on esoteric points. They're lost on these fundamentals. And if there is one golden rule in this area, it would be: do not antagonize the jury or the judge. It seems so obvious that one shouldn't have to state it. But we live in difficult times, and I'm going to make a statement which will absolutely stun you. Lawyers are not particularly popular. The very fact that you're a lawyer in a courtroom means that to some people you're going to be obstructive, technical, and probably aggressive. So to a certain extent, particularly in a libel trial, you really have to act like a lawyer without seeming to be a lawyer. And I think you're going to find that's a recurring theme in this panel. The first rule is don't irritate them. And the one thing that juries hate, you'll see in the material a reference to Stephen Brill's Trial by Jury, and it comes through very clearly. That's a wonderful book. It seems as though the lawyers are on trial, And even small gestures can annoy juries. For example, there was one very elegant counsel who was very polite, but when he wanted a text, he would reach blindly behind him for the book, and his junior, who was about 65, would slap the book into his palm, and he'd produce it. And as you know, in the States, they can talk to jurors afterwards, and for some reason, that drove them crazy. The juries that we have had in trial practice cases and the committees before whom we appear on discipline matters, because we all do discipline matters, are all unanimous in this. They hate aggressive lawyers. They hate witnesses being badgered. And the Chief Justice can tell you better, but my belief is that judges feel exactly the same. Now, sometimes you have to be firm, and sometimes you have to make a point, but there's a way of doing it. So I think if we start from that premise, the premise is don't antagonize the jury. You're there to persuade. You cannot persuade someone or a group of people who don't like you.
All right. Bob, have you got anything?
Well, just following up from David's theme, again, in a sense, another kind of penetrating glimpse into the obvious, but particularly before juries, I've noticed that some lawyers decide to undergo some kind of personality change and try to become Perry Mason or somebody else. And along with my two colleagues, I was fortunate when I started practicing law to be able to see some of the really great lawyers at trial. I mean, regularly, Dubin, Robinette, Martin, Maloney, Sedgwick, Williston, great lawyers, but all very different personalities. They all had one thing in common. They were superb at what they did, but they all did it in their own way. I never saw Chief Justice Dubin, when I was carrying his bag, try to be Robinette, or Robinette try to be Dubin. They did their own thing, and they did it very well. And one of the handouts here is the opening address of Irving Younger. And I mean, just as an example, he starts by saying, may it please the court, ladies and gentlemen, the judge introduced me to you earlier this morning, but it was across the length of the courtroom. So let me give you a chance to get a look at me, moving from behind the lectern again, and let me remind you that my name is Irving Younger. And you go on through his address. It's very good. But I can tell you, as I read it, I couldn't give that kind of address. I mean, I couldn't step out from behind the lectern and say to the jury, you saw me earlier across the courtroom, but how would you like to get a look at me? I'd be just a little worried that the response would be exactly as the response here. Julian, in his younger days, might have had some mild attraction, but even he, now that he has a few miles on him, it probably wouldn't work for him. So, be yourself.
Julian.
No, that's, Armstrong has disguised his real personality very well. No, it's interesting. It depends how long your trial is. I'm sort of a belief that you can exhibit more than one personality in a trial, but it depends how long, and you really do have to, if you have a jury, the whole point is that you must identify with them, and I think I'll talk more about it when we reach closings, but I think you can exhibit a couple of personalities, but you better pick them carefully.
What about the overall considerations if it is just before a judge alone? What type of things would you consider?
Well, you've asked me to, this is a really big decision. I think if you're acting for a professional person, you might very well wish to go in front of a judge alone. Of course, now either side can serve a jury notice, so you can't control it yourself. But a professional person, a judge would really understand the plaintiff's problems and wouldn't be jealous of the plaintiff. However, it's a completely different lawsuit. It will then be a lawsuit without emotion. It'll be a lawsuit that you will be entitled to make objections in quite a firm and aggressive way in front of a judge alone, which you couldn't do before a jury. If you're acting for a corporation and there aren't any actual damages, I think the law is now that the most a corporation could get without proving specific damages or prospective damages would be about $85,000. It might be a lot wiser to go in front of a judge. I say carefully, even though since Capito it is impossible to really be in contempt of judges when talking of them, but some judges are better than others. Some judges that you can draw in a panel here in Toronto, and you see they may take a libel case, you may weep. At that time, you may wish you had a jury. Certainly the trial's entirely different because you'd hand up a book of exhibits, your opening would not be emotional, and it leaves you without the very emotional argument. However, it does have an advantage. It means you're less likely to have an appeal if it's a good judge and if you win, and the judge won't return with a verdict that's so crazy you have to go back through an appeal and fight it all over again. But that's a big decision, thinking about that.
You've talked about the emotional aspects. How far do you go when you're questioning witnesses? And I know we will be dealing with specifics afterwards, but generally, how far do you push when you're dealing with witnesses?
Can I just want to follow up. I answered that question by following up on Bob's point and take the specific example of Julian. Julian has a very distinct and very successful style, both in his addresses to the jury and his examination. I have seen a trial in which someone tried to be Julian and it just did not fly. And I think that there are things that Julian acting for a plaintiff who could probably get away with that someone else acting, particularly for a corporate defender or broadcaster, couldn't. Would you agree with that, Bob?
Oh, yes, I agree. Yeah.
Good boy.
Good boy.
Man, you feed him those leading questions, he knows what to do.
In a libel case, probably more than any other case, the lawyer is in effect on trial. What, because of the effective conduct in the case, what type of things would you suggest to our audience here as far as tactics and strategies to use or not to use?
Well, I guess I think David's going to talk about objections. Do you want to talk about that now?
I think
because it
just
comes
more
into
the overview, if you have any points. If not, we can go into the actual specifics of a trial.
I think it's easier to illustrate with the specifics if we go through it, don't you?
Yeah.
Okay. All right,
Yes.
then why don't we go and start off into the next part of taking a look at the opening statement. And we could start off with Bob on some of the things that perhaps what the opening statement is intended to accomplish.
Well, again, there's a lot of information on opening statements and closing argument. There are chapters in books, there's lengthy lectures on the subject, and much of it is, again, stated logic or stated common sense, but it doesn't hurt on a Friday afternoon, I think, to just reflect again a little bit on some of the obvious things. Obviously, an opening statement is your first opportunity not only to introduce yourself, or introduce your client, but to introduce yourself. And as Vicki has stated, and as will become apparent through our discussion here and perhaps through the earlier discussions, that the lawyer's role in a libel case is pivotal. And the jury, or the judge for that matter, perhaps obviously the jury less than the judge, will identify you and your client in much the same order. So, as I indicated in the short little paper I did, if first impressions are important, your opening statement is very important. I think the first point to make about an opening statement, it's not argument, and you've got to be careful not to argue. On the other hand, it's not just an opportunity to kind of stand up and introduce yourself and say this is a defamation case and my first witness is. There is no reason not to be persuasive in your opening statement. So your opening statement should be organized in a very clear, simple, logical fashion. You want a theory, and by the time you go to trial, you'll have your theory presumably inside out. I'm not a great believer in all that I read that the theory of a case just kind of runs up and knocks you over 2 minutes after your client walks in the door, and that the theory of the case is something that you've been thinking about for 5 years. But obviously, by the time you get to your opening statement, you want that theory. You want it stated, I think, in about the first 3 sentences of your opening statement, and it should be there loud and clear. Then you want to tell the jury what the story is and what your client's part in the story is, and what the injustice is that was done to your client, and how they are going to right this injustice. There are some don'ts. Don't waive an opening statement if you're a defendant, and indeed if you're a defendant, the most people on this subject will tell you to open right after the plaintiff, and under the rules, of course, in a jury case in Ontario, you, with leave of the trial judge, can open right after the plaintiff. If for some reason you don't get the leave of the trial judge, or if for some reason you don't ask to open right after the plaintiff opens, don't waive the opening when you come to put in your evidence. Don't simply stand up and say my first witness is, because you're losing a great opportunity to tell the jury what this case is about, really in a ex-parte fashion. And another don't is, of course, don't misstate the evidence, and if anything, understate what it is that you anticipate the evidence will be. Don't give the jury a lecture on trial procedure. Opening statements and closing arguments are very precious moments, and don't waste a lot of time on stuff you don't need to waste time on. I mean, I hear lawyers open to juries and start telling the juries all about what a trial is since 1600 and how it's going to be run and so on. That's what the judge gets paid for, and let her or him do it. Open, get to the point, tell them what the case is about, and tell them what you want to do and why they should do it.
Julian.
Well, that's a great talk by Armstrong. Have you looked at that paper? 4 pages. And you know, he scalped 2 authors in the 4 papers. There's a concept under copyright law of fair dealing. 57% of this man's paper is stolen from other academics. So
I
from
got
now
50,
on,
50 witnesses here
at the best of
defamation case.
At the best of days, it'd be known as fairly Armstrong. Openings are much tougher than closings. If you mention law, a judge may very well tell you not to. We don't have a great history of openings in this country. They've got at the back of the material an opening by Irving Younger. You really should look at it. It's a wonderful example of how somebody with a lot of imagination can try and introduce all the players, and what Younger does in a very long opening. Because if you read it considering the pages and time, I think you'd have trouble doing an opening as long, but he goes through the whole case. He's defending the Washington Post. He introduces all the players, how a story came, what happened with the story, and he's gone through the whole story. It's very dangerous and difficult to be emotional when you open. You've got to really consider whether your plaintiff, who usually has to be the first person in the box, is going to be a good witness. The plaintiff's only going to be an ordinary witness. Maybe you better open up a bit, and because you'll do a lot better job than he will. which Dave Humphrey used to say, asked whether he would ever open in a criminal case, Humphrey said, well, I can do it a lot better than my client. So that's not necessarily true with Mr. Armstrong, but in any event, considering he's got the largest award, I better be quiet. So openings frighten me because I get too cautious with them. And
You cautious?
too cautious because if you overstate it, you can't mention law, and so it's very hard. You do have to have a theory, and I think you've got to try in the opening at all accounts with a jury to stand very still and to talk very quietly and identify with them as a person. That is almost more important than anything else.
I had something very, I think you've got to think in terms of the opening before you if you're the second person. If Julian's open, you better take a box of Kleenex because the jurors will be weeping. You do the same thing with Bob, but in his case they're weeping with laughter. But you've got to judge the opening that went before you. For example, in a case I had with Julian called the second trial in a case called Walker Brothers, he somehow managed in his opening to portray a waste disposal company as close to Little Orphan Annie. And when that happens, it's foolish for you to go up and try and make your broadcaster look human. You've got to bring in the people who were involved in the broadcast, and you've got to bring the jurors back to the facts. You can't fight fire with fire in that situation. Bring them back to facts. They hear the issues. You know, always interesting to hear Mr. Porter, fascinating, but here are the facts. Because if you don't neutralize someone like Julian at that stage, you're in trouble until you get your shot at cross-examination or your case.
What kind of dangers would you try to avoid, David, if when you're doing your opening?
Well, I think the others really have covered that. Is my view is if, and most of my work has been for defendants and usually broadcasters, and sometimes you can sense a real anti-media bias in a courtroom. Perhaps not as much as a bias with some other defendants, Bob, but you're crazy to open high for a broadcaster or a newspaper.
But there's one thing you do have to tell and get across to a jury very quickly is that damages are presumed. Everybody thinks, almost everybody, other than the lawyers that do it, they'll say, well, the person hasn't suffered any damage. And so you must tell them, if you're for the plaintiff at the very beginning, that this concept of presumed damages, you don't use a case name, and you must, I think, explain what defamation is. And there are one or two cases. I mean, one case which is accepted, which Mr. Justice Sapinko always refers to, is that damages are words said to a person's discredit. So libel. Libel is words said that discredit a person. So you get first whatever your definition is. I wouldn't use hatred, ridicule, and contempt because people sort of laugh at it. But you do have to set a couple of rules without using a case name. I think you have to find some analogy to discuss with them that when it comes their time to consider the matter at the end, there will be a discussion which her lordship or her ladyship will tell you about presumed damages. And I just want to tell you a word about presumed damages. I think you should do that, as opposed to discussing the defenses, which are harder and more technical.
If I could just follow up on that, Vicki, then the flip side of that for the defendant is you've got to, that illustrates the point I just made before, you've got to immediately say, now, let's, all right, they're presumed, but let's look at what are the elements. Did they lose business? What flowed from this, particularly with a corporation? because you've got to bring it back. Julian wants it up there in the nice subjective stratosphere. You, if you're for the defendant, you want it back down to hard economics.
Just another issue in a libel case, of course, too, if you're acting for the plaintiff, I think, in opening, just as you want to deal with the fact that your client may not have suffered actual lost income or lost business or whatever, you may want to tell the jury, in fact, I think you do, if there's been an apology. But I think you can put the apology in a way that is an attempt to persuade the jury in opening that it's just too little too late, and just say to the jury, you may think that an apology is the end of the matter in a libel case, but you'll see the evidence, and you'll see that here is where the article appeared on page 1 of the particular newspaper, and you'll see another exhibit where the apology appeared in the classified ads beside an ad for trusses or whatever. And so I think you should deal with the apology in the opening too, and conversely, from the defense point of view, you'll want to say this is all a tempest in a teapot, it was a 24-hour wonder. You can't say that's argument, but you'll do it in a way in an opening that you'll say, look, my client apologized, and I really don't know why we're here.
The other problem is that
Did you hear McCall and Dearden and Rod, all these acting for the large paper that, oh, they don't want money, they just want an apology. Under corrections on page 2, the first correction is, we said Prince Philip was head of the World Wildlife Fund. We're sorry, we're wrong, there's the World Wildlife Inc. And then that's your kind of correction. We said he was a director of the Catholic Benevolent Society. He's not a director, he was president. Correction. And boy, have you ever seen a paper ever say, I'm sorry, I apologize? Rogers will say, oh, the charter says we shouldn't do it.
I think the flip side of that is if you haven't apologized and you're defending on the basis of truth, you're whipsawed, because if you're against someone like Julian, he's going to keep saying they haven't apologized. Of course they haven't apologized, they're fighting it on the merits. But he doesn't care, he just keeps saying, and there's no apology every time. Should we break for lunch? Sure, there's no apology.
Okay, let's go on to examination in chief, and perhaps Julian could start with this. How do you prepare the witness for the examination in chief?
I put in the material, it's G1, and I've done that sort of carefully because my theory is, if you look at that material, which speaks for itself, is that you elongate the frame of time that the plaintiff discovers this dastardly libel. You extend it as much as you can. So you see, if somebody were having a story written about them, and did you hear from the defendant when you were at City Hall? That is the paper. Did you hear from the defendant when you were at home? Did you hear from the defendant when you were at work? Did you have any reason to expect a story on you on September the 1st? And you go through, make it step by step by step, because all of it we're fighting against. Your theory is that the newspaper or the person that wrote the letter should have checked with you, should have been careful, should have checked with somebody else. So all the time you're trying to set the facts against that background. And then the big thing that you have as a plaintiff, which the lawyer can't do, is the time you discover it. I went to the door, tell us about the morning, Mrs. Jones. I went to the door, I picked up the paper, I opened it, and I sat at the kitchen table, turned to page 2, I saw my picture, I spilled my coffee, I started to cry. My sister heard me. She came in, she said,
kids come in next day from the schoolyard, say it's not so. Say it's not so. And the advantage of a libel case for the plaintiff, and it's a big decision you have when you're suing if you just try to go for the presumed damages. If you try to claim actual damages, then of course you must produce all your books, and then you get into an everyday sort of case where you might be fudging with your books, you might be lying a little bit about your business, and these defense lawyers are very, very good. And they can cross-examine you very well on your books. They've done it for years, and every time you've either tried to fudge with the income tax department or you've tried to increase your costs, it's all out of control, but they can't question you effectively about the punishing bruising that you received because of that awful article. They can't get at it. And they really can't get at it to some extent when you can say, because you can say the kind of thing, well, I couldn't, well, what happened? Well, I couldn't sleep. I couldn't sleep the next day. Couldn't go to work. Please, do you want a break, Mrs. Smithers? No, I want to get over this. You glare over at Stockwood, who's got this big Queen's Counsel gown. And so that is what makes the trial different. If you break your leg, whether you're a lovely person or not, doesn't really have much to do with what the damages are. It may in terms of general pain and suffering, but you are describing the crumbling of your moral dignity. And the libel suit is for the plaintiff trying to restore a person's moral dignity. And that's quite a thing. And I've used Bob Armstrong's example. I've set it out. I haven't poached the way Bob did. I sprinkled throughout. But Bob did a wonderful job with Casey Hill in the box. And you see how Casey Hill talked about his reaction to the broadcast. And it was a wonderful bit of advocacy, and wherein everything comes to that 8 or 9 or 10 minutes when the person's talking about his own perspective of his own reputation, which is quite subtle, but that's what makes it different, makes it fun.
Okay, Bob, what type of line of questioning do you use when you are doing your examination in chief?
I wondered when Julian was going to get to tell us what the counsel did in one of these trials, because we know now what the plaintiff is supposed to do, bring a large supply of handkerchiefs and wine. But I did just picking up, not obviously the last bit from Julian, because there's one case I'm not going to talk about here, and that's the case that Julian just referred to. But picking up the point about presumed damages and the plaintiff who was promoted since the defamation, or the plaintiff who hasn't suffered any actual damages, I think it is very important to spend a lot of time with her, finding out from her just exactly what the sting of this libel means to her or him personally. I mean, we can all put into our own words as counsel what the sting of the libel is, but I think you want to spend some time with your client, just sitting there talking to them and saying, you know, as Julian said, how did this libel affect you? And it's almost, I mean, it really is the rare case. Bauchuk, which is another case that is before the Supreme Court of Canada and will be argued in a month's time. Bauchuk is almost the rare case, and Vogel is almost the rare case where you can actually prove that a plaintiff has suffered particular damages. And Bauchuk seems that, again, it's difficult to talk about that case because it's before the courts, but there clearly was evidence in Bauchuk that his law practice had suffered. But that's the rare case. I mean, if you look at the Jerry Wiley case, another Crown Counsel case that's finished long ago, gone to the Court of Appeal and so on, Wiley didn't suffer 5 cents worth of actual damages. But he was able to tell his story as a lawyer, what it meant to be described, in effect, as a dishonest lawyer, as a lawyer who would misrepresent himself to the police as a Crown Counsel. And he took some time in describing that to a judge alone. And he said it in his own words, and I think what you want to do is spend some time, as I say, with your client so that that client can comfortably express in his or her own words just what the effect is.
Perhaps we could turn to David now and look at it from the defendant's perspective. David, what type of questioning do you go in trying to do the examination of Chief with the defendant client?
No, before that, there should be a commercial break. There's a Julian Porter doll available for Christmas. You put it in front of a jury and it cries on demand. But for the defendant, you've got to humanize the defendant. So you put in your most likable reporter or person involved with the thing. Sometimes you don't have any control. But I've got there's a really technical hint here I'd like to share with you. If you break for lunch halfway through your client's direct examination, make sure he doesn't have 6 double vodkas. This can definitely change the impression on the jury. You've got to explain to the jury that there are people working on this story, and the front person, the reporter who does the stand-ups on TV, is perhaps not the most sympathetic, but usually has to take the lead. But also call the people who wrote the program and put it together and explain what they did. You'll notice that in the younger opening, he's telling 2 stories. He's telling the facts, but he's also telling what the newspaper did. Because you see, the jury's sitting there just assuming that this callous newspaper or broadcaster just went ahead with this to make money. And you've got to explain that these people are trying to put out the news, and they're working hard at it, and this is what they do. So, in a nutshell, you've got to personalize the defendant, and that's a lot harder than personalizing the plaintiff.
Okay, I'd just like to move next on to objections and when they should be made in the form, and how not to alienate the judge and jury. And perhaps we can start with you, David, and emphasize when they should be made. Perhaps we can start off with
Well,
that.
there's a really key, some people don't take advantage of the fact that you can go before the judge and you know what major objections are coming up. Go to the judge in chambers with the other counsel and say, I anticipate these, and argue the objections before you get going. Now, why would your opponent agree to that? Well, your opponent might be sacrificing a slight tactical advantage if he thought he could make you look obstructive. But on the other hand, if you get the objections out of the way right at the start, and the judge has got to agree to this, then he knows, and you know, that the flow of the story is going to go in relatively unimpeded. So try and deal with it before the jury's even in the room. If the jury's there, you stand up and you say, my lord, my lady, or your honor, or whatever we're required to say now, there is a matter which I would like to discuss with you in the absence of the jury. The jury aren't sure what you're doing. You don't look as obstructive. You make sure that it's low key. And really a very simple, I guess I should go back to the basic principle, is keep your backside in the chair unless you just have to get up, certainly if you're acting for a defendant.
Julian, would you?
Well, if you obviously that's the way that you want to try it, but if you're acting for a plaintiff and the defendant starts to cross-examine and you are getting a little worried that the defendant may be, you know, as David Potts said earlier, so much depends on how these actions are pleaded. And if it's pleaded in justification, which is truth, they have to set out what the particulars are before the discovery. And when I say particulars, it's rather akin to criminal particulars. You've got to really have details. Not that you pulled horse races. You pulled a race on June the 7th and the third race. And you have to have details, and you can only discover. So if you're in a trial and suddenly the person's trying to cross-examine your client apart and separate from the pleadings, that is, when it hasn't pleaded truth, but is maybe in front of you, you might wish to make an aggressive objection. And you might always frame it in fair. It isn't fair what my friend's doing, and that he's been afraid to raise this in the pleadings, and now he's trying to sneak behind and do it. And of course we would have answered, but it was just afraid to say this in the statement of defense. And now you see him at the last minute trying to raise this new defense, which we weren't entitled to. Would you get to your point, Mr. Porter? Just wait, Mr. Wade. You weren't entitled, and it isn't fair. And so you can try that. You might always consider at some point letting the jury know. The magic is that if you have an aggressive lawyer against you, you will then want to try and blend the lawyer with his client, no matter which side you're on. And at some point you may be telling the jury that one of the unique things about damages in a jury trial is that the jury is entitled to assess the conduct of the defense lawyer. And if the defendant's lawyer has done nasty things at trial and aggressively suggested that your client might have done bad things or pleaded truth when he or she shouldn't have, he will pay in the end. You might not want to say that early on in front of the jury because it will warn your rival. But remember, at the very end, when you address the jury, there's one other element of damages: the conduct of the defense's lawyer. And that's beautiful, because it doesn't get you in any trouble at all. And then if you're in trouble on sort of the merits of the case, you can hammer away at the lawyer. And you know, if you're against Stockwood, can I say more? Who defeated me the other day, so I am not pleased with them.
Well, I'll just add a thought or two. I don't like to agree with Julian, but I will. I think there are rare cases, and perhaps not so rare, where it is an opportunity, particularly if you're acting for a plaintiff and the defense counsel is going beyond the bounds in cross-examination, then rather than get up and utter the stock phrase, "My lord, there's something I want to discuss with you," in the absence of the jury, and the jury sort of looks bored and trundles out one more time, I think it's quite useful sometimes just to stand up in front of the jury and appear to be taking on this great corporate defendant personified in this nasty lawyer, and just reminding the court and the jury of the unfair conduct that is being carried on by him or her, and make your objection right there. I mean, it's not grandstanding. It's just making clear to the jury that you're there to see justice is done for your client, and there's nothing wrong. Occasionally, if you can make a short, sharp, effective objection with the jury there, and if the defense withdraws in the face of that, so much the better. If she or he doesn't, then the judge will send the jury out, and you better hope you win the objection when they come back.
But you'd agree you don't do that too often.
I think it's the rare case.
Okay, I'd like to move on to cross-examination, and we'll deal maybe with cross-examination of the defendant first, and perhaps, Bob, we can come back to you. What things should be accomplished when you're cross-examining the defendant, and what tactics do you use?
We've gone away from the crib sheet, but that's all right. Stockwood sent me a list of things that I was supposed to speak to. I think there were 2, and I've exhausted them. So I'm happy to have something else to speak to. I was going to talk about cross-examination of the plaintiff, and of course, and somebody else will say this, but let me just say, when you're cross-examining the plaintiff, it surely is the one time in our practicing life that you don't cross-examine if you haven't got something to establish through the cross-examination. You sure as heck don't ask a question that you don't know the answer to. We break that rule all the time. I do it all the time, but it's the one time that I try not to break it. As far as the defendant is concerned, I think you want to concentrate on what that defendant did. If she's a newspaper reporter or a broadcaster, by the time this case gets to trial, you know so much more about the case, presumably, than she does or he does. Or at least you know so much more about it than they knew then. And so I think you want to illustrate during the course of your cross-examination, when they wrote the story, delivered the broadcast, wrote the letter, just how little they knew and how little they didn't do. You know, did you do X? Did you do Y? Did you talk to A, B, and C? And of course, you know they didn't talk to A, B, and C, and you know they didn't talk to X, Y, and Z. And for me, it's an effort to illustrate that if you're cross-examining a defendant in a libel case, that they really proceeded with not much care and not much caution.
I set out at G10 and G11 what I believe is, and G12, to support what Bob says, the basic premise of examinations if you're dealing with a story. And those 7 questions I call Charles Dubin questions. And they are basically, you don't have any leverage in any of the questions at all. And of course, Chief Justice Dubin, when he was at the bar, had a method of cross-examining which was quite different than everybody else. Most people, when they cross-examine, pretend that they know what the answer is. The lawyer is sort of reaching, you know, I put it to you, I suggest. But Mr. Dubin, as he then was, always questioned as if he was basically utterly amazed with what he was hearing. But you see, you look at those questions that, you know, you wouldn't wish to print a falsehood about the plaintiff, would you? Can't say no to that. You wouldn't wish to hurt the plaintiff, would you? And then, so that is, the concept is you're setting in your cross-examination the reporter's conduct against an ideal. And also mentioned earlier, if there has been an apology, it's a wonderful place to apologize, to deal with the apology. Usually, when television or newspapers apologize quickly after a notice has been served, they resent having to apologize. They're quite angry. Everybody's still angry. It takes about 3 weeks for people to sort of settle down after they receive the notice and statement of claim and say, wait a minute, maybe we've done something wrong. What immediately happens, everybody goes down to the bar and they, oh, we'll get them. We won't do anything. In spite of Rogers telling you that they all wring their hands and lament and consider the truth and duty there. He's wrung his hands in his life. They all go down, say, we're really going to fight this. And then after a little while, they think, gee, you know, maybe we don't have that evidence. And then suddenly the person says, well, what I said was off the record. So you work out in your own head what a real apology would have been. And the law of apology is you must say that you're wrong. You must say that you're sorry. And you can't go on to say, I didn't mean to say. You know, I'm wrong and I'm sorry, and I withdraw without qualification. Basically, that's it. So you can set what they've done against the ideal apology, just as this cross-examination is to set what they've done against what they should have done. And lastly, what I've done in 12 is you can always weave into every cross-examination that the reporter was interested in profit. And it's just, you can have so much fun with profit that it's just, I slaver at the thought.
Okay. I'd like to just move on to closing argument, which can be the crowning achievement in a well-presented case, or it can be the recitation of a trial which was without argument or persuasion. And perhaps Bob could start off with what a closing argument should include.
I think the first thing about closing argument is to perhaps put it in some context. It's very important, as Vicki says. On the other hand, think about how many Joe Carter home runs in the bottom of the ninth inning in a World Series game there have been. Think about how many Paul Henderson goals in an international hockey match there have been in the last 2 minutes of the game to win the game. They're a rarity in sport. It's a rarity in life to snatch snatch victory from the jaws of defeat. So in many respects, if you haven't made it by closing argument, you might just as well pack it in and go over to Porter and offer him a few dollars to go away. If the evidence ain't there, it ain't there. No closing argument is going to do you much good if you don't have the evidence and your theory that you've opened with hasn't been proved. In any event, it is your opportunity, assuming that the evidence is there, to pull the whole case together in clear and simple terms to demonstrate that on the evidence, in fact, you've proved the theory that you've opened with. And I like to open with a theory in the opening. I like to close my opening with a theory, and I like to open the closing and close the closing with the theory. And I think that's one of the most important things. A couple of the don'ts. Closing argument should not be a recitation of the evidence in detail. I mean, just, again, obvious thing, but so many counsel stand up at the end of a case and start with the first witness and go through the examination in chief and the cross-examination, then to go to the next witness and so on and so forth. I mean, it just establishes nothing. The court has heard the evidence. If it's a judge, she or he presumably understands it. Some of the tough evidence you'll want to deal with. Take, in my view, the evidence first that helps you, summarize it neatly and put it to the jury and tell the jury why it supports your case. Take the evidence that's against you and deal with it and tell the jury why it doesn't matter. Don't squander the closing in either a jury case or a judge alone, but particularly in a jury case. The closing is the one time when you stand up and all 6 eyes and ears are on you. They're waiting to hear now what you're going to say about this case that's just going to tie a great big red ribbon around it for them. So I get totally bored, I must say, by counsel who start telling the jury how important they are and how attentive they've been listening to the evidence and how many times you have to thank them. I just do not do that. I just go right to the case and tell them what it's about. We're getting late. I've got a lot of notes on other things to do and not do, but Porter, I'm sure, is going to complain that he hasn't had enough time, so I'll stop.
It's the first time in his life.
I think that a closing in a libel trial for a plaintiff is about quality of life. So you're going to restore your client to a quality of life. So that allows you to describe present and past pain and future what life should be like. Or you can talk about how it was before the libel. Quality of life. So you take a case away from words and make it into a whole atmosphere, and that this person's quality of life has been ruined, and they have a chance of restoring it, because a court cannot order an apology. And because a court cannot order an apology, the only thing you can give is money. And if my client was here with a broken leg, every day that pain hurt, and he limped, you'd understand that. You'd pay money. And so every day, my client, you saw her, every day she's lost the one thing that really counted, was the quality of life. Secondly, I take the questions to the jury, although in theory a jury can return with a general verdict, just find for the plaintiff, find for the defendant, damages, if any. That can be done, but today everybody prepares questions. Be very careful with those questions. You insist that they have a copy of the questions, like, was it published by the defendant? Is it of and concerning the plaintiff? Is it defamatory of the plaintiff? Yes, no, yes, no, yes, no. So you have it, and you say, and you really take time. You say, now I want you to put yes there, and no there, and yes there, because the questions become quite complicated. Is it true? If not, this, and when you look at the questions as set out in Gatley and what the judge will be doing with you the night before the jury address is establishing what those questions are. Well, you've got to leave them with no doubt whatsoever how they will actually fill out those precise little ballot box entries. And that's very important and very specific, and that you've got to slow down all the other rhetoric of your trial, because there have been some trials in the history of libel in this country where there are inconsistent answers given by a jury. You know, they find that it's maybe fair comment but not truth, and it's all wrong. So that's really important.
Okay, and if we could finish off with David.
Yeah, well, the closing for the defendant is probably the toughest thing you're ever going to do in a courtroom, because you know the Julian's coming after you, and you know they're going to be waterworks and emotion, and you have to nail down the facts so tight that what he says is not going to move them. And the second thing, which is a technical point, but it's so important, is you have to tell them you have no right of reply. And the way you do that is to say, ladies and gentlemen, under our system, I've called evidence, and I've got to go first and tell you about my case. And then Mr. Porter will speak. But for historical reasons, I don't get a chance to speak again. So if there's some point that Mr. Porter raises that I haven't dealt with, I ask you to protect me, to protect my client's interest. And I ask you to remember the evidence and to test it against what Mr. Porter says, because that's the only protection I have. And you've got to do that, or they will be sitting there wondering why. Gee, I guess Porter was so persuasive, Stockwood decided to just stay in his chair and not say anything. You've got to say that and hope that they'll remember what you said when Julian's finished working them over.
But you've got the final word today. Anyway, I'd like to thank all the panelists for presenting a lot of information in a very informative and lively way, and also for their materials, which they've all kindly written.
Here is Patricia Jackson. She'll be talking about damages, and she's a partner at Torrey Torrey, and has a wide-ranging practice of civil litigation and administrative law, and a considerable amount of her time is spent dealing with defamation action matters. She acts for numerous newspaper chains and book publishers, and has vast experience in the defamation field. Her paper's really quite insightful, regardless if you agree or disagree with the results, and I think the table at the end is, with the calculation in Canadian dollars, is well worth the whole price of admission to the conference.
Say before anybody starts offering checks, that the table at the end of the paper is largely the product of the work of the appellants and the respondents in the Hill case, with a little additional work, in fact, substantial additional work by a student in our office. I had little to do with it. Let me also say that for the first time in 10 years of successful contact lens wearing, I have a problem with the lens in my left eye, and if I can't properly read my notes, or if something I'm saying sounds like it's making absolutely no sense, I assure you down here it does. It's extremely lucid. It's just that I can't read it properly. It struck me that the position that I find myself in the program is a little difficult, coming as it does after a lively panel of the sort that you've just heard, and just before the person you really want to hear from, which is the Chief Justice. And that probably what you don't want to hear from me, and probably don't need to, is a dry treatise on all of the things that you should consider in the law of damages in libel actions. I suspect that this topic was added to the program because of the topicality as a result of two recent cases in the Court of Appeal, now both pending before the Supreme Court of Canada, the Bauchuk and the Scientology case. I'm going to try to be careful what I say about those cases, because they are pending before the Supreme Court of Canada, and partners of my firm are involved in both of them. But I think we can't ignore the significance of those cases and the decisions of the Court of Appeal as we await the ultimate outcome. And I think there are a number of things that we should all have in mind as we go forward after those cases in trying to decide exactly what they mean and what they don't mean. It has been said by a number of people that both cases, Bauchuk, which has ended up at the $200,000 level after the Court of Appeal, it was higher in first instance, and Scientology, which is at the $1.6 million level when you total up the general damages, the aggravated damages, and the punitive damages, represent perhaps a sea change in what has sometimes been described as a history in Canada of modest damage awards. I'm not sure that's so, but before we get to that, I should perhaps touch a little bit on what those two cases do stand for, or what they're about. I'm going to assume that Scientology is a case that has attracted sufficient notoriety that you're generally familiar with it. And if I doubted that, I would refer you to the paper that is put forward by that proponent of original writing, Julian Porter, which quotes liberally from the cross-examination at trial and then from the Court of Appeals decision. So if you lack the familiarity, a quick flip through that paper will give it to you. Bauchuk is a case that I think is perhaps a little less well known. And I just wanted to spend a moment on it so you can put some of my subsequent comments in context. It's probably not as well known because it was a torturous case factually, both getting to trial and at trial. And that's probably fairly represented by Mr. Justice Carruthers' decision. The case was tried before a judge alone, which ran to 114 pages. And the Court of Appeals decision, which affirms on most issues except for an adjustment to one aspect of the damages evidence, or damages finding, is quite short and refers you back to the 114-page judgment that I suspect very few people have ever read. The case concerned a lawyer, Mr. Bauchuk, in the Ukraine, who was quite prominent in the Ukrainian community in which he lived and practiced. And he had been involved in helping quite significantly in a public inquiry that affected a number of issues that were of interest to the Ukrainian community. 3 publications were made in connection with that inquiry long after it occurred, or substantially after it occurred, way back in 1978, including one by 8 lawyers who had been, they said, involved in the public inquiry, and who said essentially that Mr. Bauchuk had promised to give his services for free to this inquiry, that he'd subsequently, in violation of that promise, taken $10,000 by way of payment from Metro Toronto. He had not given it to the Ukrainian community as he had, the Ukrainian Canadian Committee, as he had promised to do, and that was to the detriment of the Ukrainian community and the immigrants that that committee was set up to help. Now, that's a fairly unusual allegation, but it had the evidence indicated it had a very substantial impact in the community in which Mr. Bauchuk practiced, which was largely drawn from the Ukrainian community. I should say there were 2 other publications, not by lawyers to the same effect. And as Bob said, in contrast to what usually happens in a libel case, there was substantial evidence of that damage, specific evidence of it, and it was reasonably clear that it was serious 12.5 years after the alleged, well, I guess we can now say found libels occurred. In fact, there were instances at trial of people hearing 2.5 weeks before the trial, which occurred 12.5 years after the libel, that this man was being called a liar and a thief and a crook as a result of what had been said about him 12.5 years ago. So that, I'd suggest, takes it well out of the realm of the kind of ordinary libel, of the kind of libel case that most of us may be dealing with. The judge who heard the case, Mr. Justice Carruthers, awarded $140,000 in general damages and $325,000 in special damages, which he said was based on the evidence of a forensic accountant at trial who estimated that this had an impact on Mr. Bauchuk's practice that ran to approximately 10% of his income per year. The Court of Appeal's decision generally was short, and on the damages point in particular short, but the general damages of $140,000 were upheld, but the $325,000 was reduced. And the court said, particularly because of the pleading, and the pleading there was one that alleged general damage, including damage to Mr. Bauchuk's profession and reputation, and because of the nature of the trial evidence, although the Court of Appeal didn't say what it was about that evidence that caused them to come to this conclusion, they thought an award for this professional loss of income was appropriate, but appropriately included under the general damage award, and they reduced the entire award in total to $200,000. And they said at the end of the decision, we appreciate that this is a much higher than is ordinarily awarded in libel cases, but went on to note, as I've indicated, the very serious and specific effect of these libels on Mr. Bauchuk. I suppose if it came to them today, they might not say it was much higher than ordinarily awarded, but they didn't have the Casey Hill case in their sights when they said that. Leave to appeal has been granted to the defendants, and I think you've already been referred to the fact that the case will be heard in the Supreme Court of Canada next month. And on the question of what it's going to tell us about damages, it's pertinent to note as well that the plaintiffs have cross-appealed and have asked for the restoration of the $325,000 verdict. There are a number of issues that may be determined by the Supreme Court of Canada in the context of that appeal, which I just point out to you because you'll want to keep your eye on them if they are dealt with by the Supreme Court. One is the question of the circumstances in which there may be joint liability on a group of defendants, even in circumstances where they have not participated in all of the defamatory publications. Here, the 8 lawyers who were involved in one publication, but not the other 2. The question that the Court of Appeal has dealt with, and that the question of whether and in what circumstances loss of income or profession is reflected in a general award versus a special award, and what kind of proof is required for each of those. I think we can expect to hear something about that from the Supreme Court. The case also raises the question of whether delay in bringing a case to court is something that should be considered in damage terms from 2 perspectives. It was said, one, that the plaintiff's successive counsel had delayed in moving the case ahead in a timely fashion, and I rush to add that was before they were represented at trial by my partner. And it said on the other side that the defendants have contributed substantially to that delay by bringing a series of unsuccessful interlocutory motions. Does that matter? And if it matters, does it matter in a damage award generally or only in prejudgment interest or both? That issue, at least, is before the Supreme Court of Canada. And then I guess lastly, and perhaps the issue on which I will spend most of the rest of the time I have, the question of the of the scale and the quantum of the award. The issue that is also going to be before the court in the Scientology case, should there be some sort of limit on libel awards in Canada? Now, as I say, it's clearly also before the court in the Hill case. I don't wish to try, nor would it be appropriate, to predict what the Supreme Court of Canada is going to do with any of those issues. I thought it might be useful, though, to talk a little bit about whether those two cases, and I guess particularly Hill, as they now stand from the Court of Appeal, represent a sea change in the approach to damages in Canada. The secondary question, which seems to flow from the cases that have awarded damages to the 6 or 7 figure level, should damage awards be limited in Canada? Is it appropriate or practical to scale them back to a purely nominal level? And thirdly, whatever happens in the Supreme Court of Canada, are there some teachings from these cases that would help those of us that find ourselves representing defendants avoid that kind of ultimate outcome and at an earlier stage minimize the risk of that outcome in going to trial? I should say, I'll probably say a lot less about that last issue because of the extent to which it was so ably dealt with by the panel that preceded me. But let me talk a little bit about this question of a sea change. It's often been said, and indeed it's been said by some judges in Canada, that we have a history of modest awards in libel actions in relation to other jurisdictions, chiefly, I guess, the United Kingdom, which has been up in rather large numbers, as you'll see from the chart at the end of my paper, and more particularly, our neighbors to the south. I don't say that we have reached we typically reach the levels that either of those jurisdictions, but I don't think it's correct to say, and I think it's skewing our thinking if we do say, that Canada has traditionally had a history of modest or nominal damage awards. You'll see in the chart that's attached to my paper that as early as 1988, there were a couple of cases decided in Canada that in today's dollars would be in excess of $80,000 and $100,000 respectively. I don't think that fits anyone's definition of nominal. In 1964, there was the Platt and Time Canada case, which came in at a number that in today's dollars, and that's really the only way you can compare these things, I think, is I think close to $200,000. And of course, this issue's been before the Supreme Court of Canada before, in the Snyder case, which was decided in Quebec in '78 and went to the Supreme Court of Canada in 1988, where an award that is equivalent to approximately $300,000 in today's dollars was sustained by the majority of the court, and in circumstances where that case was merely one of 8 that were then pending in Quebec. Now, at the same time, there are, and have been throughout that period, a number of much more modest awards. In fact, it's probably fair to say more modest awards than large awards. But my point is simply we do ourselves a disservice in looking at this experience and deciding what to do about it if we pretend that they've always been modest and that they've always been nominal, because they haven't. And I think it's fair to assume that there is some assessment by the judges and by the juries as to the circumstances in which a nominal award is appropriate and the circumstances in which it is not. I have, I guess, 2 personal perspectives on why we may have come to this view that damage awards are modest. One is really less personal perspective of mine than one of my husband's, who has been in publishing for a number of years, and he started in England, and he came back in the early 70s, I think having recently read a book which may be familiar to many of you called Wicked, Wicked Libels. It's a very fine book about a number of notorious English libel trials. And my husband thought he was onto a good thing because he could see there was no such book in Canada. And he arranged to have lunch with Julian Porter to discuss the prospect of there being such a book about notorious Canadian libel trials. And I'm told that they had a very nice lunch, and at the end decided there could be no such book because there really was not very much libel litigation in Canada, at least in relation to what had happened elsewhere, and I would say probably in relation to what has happened more recently. And so it's probably it's probably part of what's happening here is that since there have been very few, up until recently, not that many libel awards, and since it was and remains the case that many of them are nominal, we have this notion that they're always nominal, but I'm not sure that they are. I guess the other personal perspective I have on this comes from my involvement just after I was called to the bar in one of the cases that I shall treasure as being one of the most interesting I was ever involved in. I hope it's not the high point of my career, but it may have been. I was asked 2 months out from being called to the bar to join Lord Morphy and Sheila Block of our firm in defending the Financial Post against a $42 million action brought by a man named Alan Manus, who was represented by those not so well-known litigators, Doug Laidlaw and Al Lenzner. And the case went on for 4 weeks and involved a very expensive case, involved witnesses from all over the world, a story the like of which I have never heard before or since. It also involved my being able to fly over at the last moment to conduct the very first cross-examination of my entire life of a witness that Alan Lenzner had typically found at the last moment in Switzerland, Alan typically having arranged that the only way we could get there was by first-class Swiss Air. So off we flew, and I thought I was into a profession the like of which I had no notion. I have never flown first-class Swiss Air or otherwise ever since. Unfortunately, although very fortunately and I think appropriately for our client, we arrived back to find that as a result of developments during the trial while we were away, the plaintiff had considered that it was perhaps more prudent to discontinue his action with a contribution towards the Financial Post's costs. Now, I give you all of that, not only to say, if we'd only continued on for another couple of weeks, my husband might have had his book after all, but also to say that I don't think anyone in that courtroom with that kind of high-priced help and that sort of trial thought that we were litigating over modest stakes. I don't think we thought we were truly litigating over $42 million, but I don't think we thought we were facing a nominal damage award. The other thing I think it's important to keep in mind in trying to assess this question is the unique features of the Bauchuk and Hill case, which in my view don't suggest, I guess Bauchuk is a case that at 6 figures is not beyond the pale in terms of what we've had before. Hill has gone to 7 figures and people say, well, it's a quantum leap. Bauchuk, I think, is unique in a number of ways because of the serious damage evidence that was led at that trial and the prolonged period over which the harm was evidently suffered. And the Hill case, which is unique for in a number of ways, which caused it, I think, the Court of Appeal, if you've read the decision, went out of its way to say the case is in a class by itself. And as we go forward trying to figure out how to live with that case and its ramifications, whatever they may be, I think it's very important to keep that in mind. I've set out in the paper, I think at page, right in the middle of the paper, a number of the factors that the Court of Appeal indicated made the case unique. They included the fact that the libel occurred several years after Scientology had opened a file on Mr. Hill in which he was described as enemy Canada, and the evidence indicated that meant that he was a threat to Scientology, a threat who should be removed at the first opportunity. A plea of justification which went far beyond the proposition that defendants should, when they've made some sort of mistake or don't exactly know where they stand, should be able to justify. A defense of justification that in that case was based on saying Mr. Hill had opened or caused to be opened documents he knew were ordered sealed by a court in circumstances where Scientology had no evidence of that, indeed had evidence that it had not occurred, had been unsuccessful in prosecuting Mr. Hill for contempt on the point, and nonetheless persisted in the plea of justification in the absence of the evidence and indeed in the knowledge that the evidence didn't exist all the way up to the Court of Appeal. a multifaceted attack on Mr. Hill's character, which is recited in the Court of Appeal and which concludes that there was no foundation for it, and very uniquely, a repetition of the libels immediately after the jury's verdict, and further attacks on Mr. Hill's reputation after the jury verdict. So I think it's important, whatever you may think of the result of that case, and there's probably a very broad range of views, to recognize that it is not a case of a publisher who made a mistake, for example. And it is important to recognize those differences. It's important, first of all, to be able to assess the tactics of a particular trial and try to learn from that experience where decisions might have been made that might have lessened the verdict. Or at least, and I have no idea what Scientology's instructions were, but if the client instructs a broad-based attack on the plaintiff, it's very important that the client at least know what the consequences of doing that are. It's important to know what the differences are to be able, of course, to distinguish the case in the cases that come after. And I think perhaps most importantly, at least from my perspective, it's important not to distort the assessment of the case when you consider with your client the risk of defending a libel action. And while I can't suggest for a second that the jury is in on this point, since the Court of Appeal's decision is reasonably fresh and the Supreme Court of Canada has not yet spoken, I think it's fair to observe that in the cases that have been decided since the Hill case was made public, and it is a very well-known case, there seems to have been no move of a different pattern of damage awards. Those cases, again, are in the chart at the end of my paper. There appear to have been approximately 25 cases decided in Canada since then. There are and remain a number of modest or nominal awards, one of $500, a number of a very few thousand, one at the $85,000 level in Ontario, one at the $300,000 level in British Columbia, and the vast majority well below $50,000, a pattern of awards that I would suggest is not at all different from what we saw before. Let me then turn to the question of whether, whatever the law may now be, would it be appropriate to move to a system of nominal damage awards? I think the proposition that is traditionally put here is, well, twofold really. One is that this is really about the plaintiff's reputation. And if a plaintiff is successful, the plaintiff has vindication in the judgment that the plaintiff gets. And some commentators go further and say the way to really put teeth in this is to require an apology or retraction and award a right of reply. When you first think about that, I at least, when I put on my hat defending defendants, which I guess I do a little bit more than plaintiffs, think that it's extremely attractive and effective at getting at what we think the problem is. But I have gradually come to the conclusion that it wouldn't work. And the reason I think it wouldn't work is that it doesn't take account of the economic and temporal, in terms of delay, realities of modern litigation. If the result of a lengthy and expensive piece of libel litigation is going to be at the end that the successful plaintiff gets, at best, a nominal damage award and a right of reply and a retraction, there's really no incentive, and litigation is invariably about the risk, the weighing of incentives and risks. There's really no incentive for defendants to offer up a retraction and apology at the outset. And indeed, it seems to me, the defendant would invariably be led on an economic calculation, and I don't suggest that this is purely an economic calculation, but economics is, of course, a real fact of litigation life. The defendant will do what the plaintiff will do. Look at it and say, 4 years of litigation, thousands of dollars of legal expense, horrendous emotional drain, and at the end, if I'm lucky, I'll get a retraction and I'll be broke. I don't want to do it, or in many cases, I can't do it. And so I think that it produces, or would produce, the wrong system of incentives. That's not the same as saying that libel cases, libel awards need to be big. They don't, I don't think. I think there are a large number of cases where a modest or nominal award is entirely appropriate. I guess the theme of my comments is it's important to distinguish between that kind of case, the case where the plaintiff may very well be genuinely and truly offended, but hasn't really been damaged in the long term, where the defendants have advanced, advanced defenses that are justifiable based on what they know and have made a genuine assessment of the strength of those defenses after discovery, and where, in appropriate cases, they have either offered or printed a retraction. I don't say that you have to have all those factors, but all of those factors or those kinds of factors operate in the vast majority of cases, in my experience, and they do dictate a modest damage award. But if the defense is carried on without regard to any of those, and at the plaintiff's expense, I suspect that it's really not that unfair that the awards are not modest. Indeed, I'd suggest that the prospect of the non-modest damage award helps to achieve the very objective sought by some of the commentators, and that is a timely retraction and apology. It may very well be, in fact, that kind of economic calculation that produced, I don't know, on the eve of the Casey Hill trial, apologies from all of the media defendants who thereby ceased to participate in the case, and a contribution to Mr. Hill's legal costs. There is, I guess, in addition to the question of whether damages should purely be nominal or modest, the secondary question of, in any event, should there be some kind of limitation? That question, including the issue of whether the personal injury limitation that's found, that the Supreme Court of Canada has given us, is appropriate in libel cases. I don't propose to offer a view on that question, because that issue is squarely before the Supreme Court of Canada. But I note that the court did have the issue before it in the Snyder case. In that case, Mr. Justice Lemaire said, not a personal injury standard, and I would not impose an absolute limit, but I think it's rare that a libel case should attract an award in excess of what was then $100,000. Now, you've got to be careful about analogies, because that case was from Quebec, where there aren't aggravated or punitive damages, and there was no issue of pecuniary loss in the Snyder case. But if you try and say, what does that tell us about what the Supreme Court of Canada is going to do this time, you have to remember as well that the only other member of the court who was around for the Snyder case is Madam Justice Leroux Dubé, and she went the other way in the Court of Appeal. She would not have disturbed the damage award in Snyder at all. So I guess all we can conclude is that the battle will truly be joined, perhaps not just between the parties in the Supreme Court of Canada, I don't know. I think it is, though, interesting to try and figure out how the Supreme Court of Canada will resolve the dilemma that was presented to the Court of Appeal squarely in the facts of the Casey Hill case. In the Casey Hill case, the jury came back after some hours of deliberation to ask the question, what are the realistic maximums that are placed on damage awards in libel actions in Canada? And the trial judge, after consultation with counsel, responded, the Court of Appeal said correctly with the answer that he could not say. That was for them to determine. As the Court of Appeal said, it would be strange to the jurors who tried this case if this case were now to tell them that judges contemplate upper limits for damages which, if overstepped, will lead us to conclude that no 6 reasonable persons could have arrived at such an award, but the trial judges are unable to tell them what those upper limits are. I think that's a very real problem with the area of libel law, particularly given the understandable propensity to try those cases in front of juries. And if the Supreme Court of Canada is disposed to put an upper limit on damages, it's a problem they're going to have to wrestle with. What should we learn, if anything, from Hill and Bauchuk? As I say, I think most of that has been canvassed in the discussion that preceded me. It does raise the interesting question, I guess, of when you choose a jury and when you don't. In Bauchuk, there was no jury. The Court of Appeal changed the damages. I don't know what they would have done if there'd been a jury. It's hard to know if the result would have been different. In Scientology, there was a jury. The Court of Appeal did not change the damages. I think what that tells you about whether you choose a jury or not depends a little bit on how well you think you understand juries and also how strong you think your case is. But to illustrate the point that it truly is a gamble and not everyone gets it right, I can tell you that in the Hill case, the defendants asked for a jury, the plaintiff opposed, and the plaintiff tried throughout the case, I think this is fair, to get rid of the jury. So there's no magically right answer. The principal, I guess the principal issue that I draw from these two cases is one that I think is applicable in any case, but it's one of those truisms that people were talking about that I think we need to be reminded of. And that is the significance of the facts in any particular case. In libel cases, that's particularly true, where the court is directed, invited, whatever, to canvass the broadest possible array of facts. And therefore, I think it's quite important to make a clear assessment at the outset of your trial to decide what your factual theory is, what are the facts you need, and what are the ones that are really only going to hurt you. What are the strategies that are going to help, because the strategies become a fact in the libel case, and what are the ones that are going to hurt you. And at least if your client wants to go whole hog, that your client understands what the risks of doing so are. The second point, I guess, is that as the Court of Appeal has emphasized, we've got to be alert to the uniqueness of those two cases, and particularly the Hill case. Those of us who are concerned about freedom of expression, and I think that's probably all of us, regardless of who we act for, and especially those of us who act for publishers, must be careful not to allow the impact of that case to step outside its unique qualities and to distort the decision-making that we go through when we decide whether or not and how to defend a libel case. I suggest there's nothing in the decision in Scientology that would suggest such a distortion or change is appropriate, and I don't think there's anything in the Court of Appeal's decision that says it should. Thank you.
Okay, I now have the honor to introduce the speaker that you've all been waiting for, the Honorable Charles L. Dubin, the Chief Justice of Ontario, who is going to provide judicial commentary on the conduct of defamation actions generally. The Chief Justice was the winner of the gold medal when he graduated from Osgoode Hall. He was called to the bar in 1944, and 6 years later he was given a King's Counsel. He was a bencher on the Law Society from 1966 to 1973, and he had a remarkable career as a courtroom lawyer. He was involved in a number of different litigation cases, including criminal and civil litigation. In the criminal aspect, he defended over the years 14 men and 1 dog that were charged with capital murder, and none was hanged. The dog who had attacked a child was convicted of assault causing bodily harm, but was sentenced to death. The Chief Justice was asked to make a pitch, and he took the case to the Court of Appeal and won. The Chief Justice was equally successful in civil litigation. He was involved in a number of high-profile cases. He had a very special interest in defamation and in media-related law, and he was the resident lawyer for the Toronto Telegram and for CFTO Radio. In 1973, he was invited to sit on the Court of Appeal, and he became Associate Chief Justice in 1987 and the Chief Justice in 1990. Over the years, he has served on a number of royal commissions, and he has had first-hand knowledge with the media and first-hand experience. He was appointed the Royal Commissioner into the use of drugs and banned practices intended to increase athletic performance in 1988, and he was head of the inquiry that looked into the practices and procedures at the Hospital for Sick Children in 1983. Over the last few years, he has received 3 honorary doctorates, and it's with great pleasure that we honor him today.
Thank you. Thank you very much, Vicki. I always made it a practice of not opening the jury at 4:30 in the afternoon on a Friday. And I insist on getting the German. But I want to thank you very much for giving me this opportunity of joining you here today. I must say I get very discouraged and upset so often when I see the rather negative perception of our profession. I think we're often painted as a greedy bunch where we enslave our juniors and are concerned only about billable hours. And the reality is really quite different. I don't know of a profession where so many members of the bar give it their time and make the effort to share their experience with their colleagues to increase the expertise of the whole profession. I don't know another group that does that, nor do I know any group where the profession themselves attend so regularly at these conferences. I want to congratulate those participating in this program and all of you for taking the time, making the effort to improve your expertise. I've enjoyed being here this afternoon, but it's rather left me speechless because it's really covered so much of the territory. But just let me say just a few general words and perhaps to share some of my experiences at the bar in defamation actions. I found, in my experience, defamation action being the most challenging of all. First of all, it's been said that the remedy that we're seeking, the wrong that we're trying to get a remedy for, is reputation. I sometimes wonder how we don't realize how important that is. To anyone of honor, a reputation for honesty and integrity and morality is their most prized possession. It takes years to earn it. It can be shattered in one line, one word, and usually irreversible. And philosophically, without getting into technique or concern about the charter, I've always been concerned of why it's assumed that somehow you could speak disparagingly of someone, defame them, without proof, as if that's some sort of a right that we should have. And we do. Also, what's overlooked, I think, in this debate is the number of defenses we have. It's a very hard role for a plaintiff to win in action defamation because of the many statutory and common law defenses. And one thing I think that's apparent in defamation, and before you consider with respect tactics, opening and closing statements, so forth, you've got to know the law. You've got to know the law at the beginning. The conduct of a defamation action is not when you stand up in trial and open up the case to judge or jury. It begins before you start the case and before you defend it. It begins before you send your notice. It begins before you send your statement of claim. Because unlike other matters, the pleadings are still vital and almost impossible to amend at trial. And therefore, you've got to know the law. Defamation actions, for some reason, are categorized, more so than contract or tort, which is flowing and changing and moving along. It's categorized. Each category is very important. And to get to know the law, you first start with the Libel and Slander Act. You've heard some reference to it. But read it. Read it. Not only because of the limitation period, which is, of course, vital, but read what the impact of a retraction will have on your damages, or an apology on your damages. Distinguish between slander and libel. Know what type of slander in which there's imputed damages, where you have to prove damage. Read about the pleadings which are referred to in the Libel and Slander Act. Also the security costs, which has been mentioned earlier today. And then turn to the textbooks. Read widely about the subject, not just the narrow point you're dealing with. Get familiar with the basic problem we have. And when you're dealing with reputation and damage, the reason why I think damages are presumed is because of the damage that's done to one's reputation. I have found over the years of all the trials I've been in, libel actions, slander actions are probably the most emotional. And also very controversial. I remember I just was thinking when I read some material today, there's a reference to how does the case look. I talk about David and Goliath. Maybe tell you a court case about David and Goliath. Some years ago, I went to Sudbury, and the mayor of Sudbury is a man called Guimond. He was suing the Sudbury Star. Guimond was the mayor of Sudbury and was running for re-election. There'd been a big debate of civic expenses. Sudbury Star had a cartoon, a caricature of Guimond. Made him look to be like Henry VIII, leaning back with a big piece of turkey in one hand, a glass of champagne flowing in the other hand, the rest of the turkey sort of flowing over the plate, and surrounding it municipal expenses. So Mr. Guimond sued the Sudbury Star. Sudbury Star is owned by the Thompson newspapers. We all went up to Sudbury, arrived there at noon, case opened at 2 o'clock, jury paneled very quickly, and counsel for the plaintiff commenced the action as follows. So, ladies and gentlemen of the jury, this is a case of David versus Goliath. Mr. Guimond is David. Goliath is Lord Thompson of Fleet. Lord Thompson of Fleet owns the Sudbury Star. He owns many newspapers, one of the most powerful men in the world. Today he's ensconced in the Bruno Castle in England, where he sends out his minions to destroy Mr. Guimond. Well, Mr. Guimond is the only person who can stand up to Lord Thompson of Fleet. And he's here to destroy the Goliath. We want you to help slay the Goliath with him. Eloquent. Eloquent. I moved for mistrial. And got it. So at 3:30, we ran away back to Toronto after having. But the case, we went back some months later and tried before Mr. Justice Grant. Mr. Guimond was a steel worker, remember, Steelworkers Union, and some of the jurors were steel workers. During the report, I mentioned the importance of questions. It was a jury case. And several questions were put to the jury, very complicated questions, because everything was an issue. First of all, was it defamatory? They referred to Mr. Guimond, where they found the normal and ordinary meaning. It's a case of qualified privilege, very common. The whole thing was there. And not because we won the case, but the jurors answered several questions consistently. Without a consistent question, there could be a verdict either way. And Justice Grant and I often comment on the fact that we sometimes underestimate the intelligence of jurors, their ability to follow the action and follow what's being said and the instructions. Also, I was impressed with the jury system. In those days, as you're probably not aware, all libel acts were automatically jury cases unless they were left to move to strike them out. Up to 1989, actions in libel and slander were tried by jury without a notice, as was the case of false imprisonment and malicious prosecution. That was amended in 1989, so that you now have to serve a jury notice or try to strike it out. But I, for one, I'm very happy with the jury system and the juries in these complicated cases. I had another very short time at the beginning of a trial, and that was a case called Gascon Retail Credit, which is reported. A case I think that probably gave me more concern and more worry than any other had for some time. Mr. Gascon was a person who lived in Woodstock, Ontario, and he had a very good job as an executive with the company, and through no fault of his own, lost his job and had to get employment elsewhere. He applied to several places for employment. The first interview was very promising. When he came back, a very negative attitude, very negative approach, and couldn't get a job. So he couldn't figure out what was wrong. He thought perhaps there was a bad credit rating. So he asked some friends of his to call and retain retail credit to give a credit rating of Mr. Gascon. And 3 of them did. And they got a terrible report. Not so much about his visibility, but about his morals. Apparently, he was alleged to have fathered an unwed mother, a child, I should say, and that he was, and that he corralled with young women, and had very moral reputation in the community in which he lived, all of which was, I think false. I say I think from reservation. So Horace Screever and I, we drove down to Woodstock, and the case was again open at 2 o'clock. About 3 days before the case opened, a friend of mine called, a lawyer. He said, "Charlie, I've got bad news for you." He said, "I have a client who's been in touch with the defendants in this case of retail Gascon and retail credit, and that evidence is not going to be very helpful to you. And that does put an issue, I think, what my client said on discovery." I thought perhaps we could meet it all right, but I didn't want to open the case that way. So we opened before the Justice Kelly, and again, before the opening, and I should say that as you see today with Stockwood, Porter, and Armstrong, libel slander cases sort of breed a special type of lawyer. And then they're usually very controversial. And Mr. David Walker, who at one time acted for the Toronto Star, Brian, before your day, was a very, very difficult lawyer, and he and I were not particularly good friends. But it so happened that just 2 or 3 days before the trial, David Walker became a senator. He was a great friend of Mr. Diefenbaker, and who put him in the Senate. So when the case opened, before the jurors impaneled, I addressed to Mr. Justice Kelly. I said, "My lord, I appear for the plaintiff, Mr. Gascon. My learned friend, Senator Walker, appears for the defendant." Senator Walker got up and said, "How dare my friend call me Senator Walker? I'm Mr. Walker in this court. I know why he does that. I might as well introduce him as a lawyer for the Toronto Telegram," which I thought was a bit of a non sequitur. And I really meant to do him honor, so I remember getting up and I say, "I'm awfully sorry, my lord. I meant to do Senator Walker honor. But Senator Walker doesn't want me to call him Senator Walker. I will never call Senator Walker again." And I sort of felt quite good about the response at that moment. And that was a very short-lived experience for me, because I decided that I didn't want to put my client in the box first. I think Julian said, invariably, you put your client in the box first, libel case. I didn't want to meet this new evidence coming up at that time. The reports were so defamatory that even though a case of qualified privilege, I thought there was an intrinsic evidence of malice. And so what I did was that I tried to prove the case on discovery. I read in discovery and asked the defendants whether they had been asked to prepare a report. Mr. Gaston, yes, they did. "And is this report you prepared?" "Yes." "And did you send it out to so-and-so?" "Yes." "Thank you very much." I did that for 3. Asked to get it? "Yes." "Did you send it to so-and-so?" "Yes." "Did you send it to so-and-so?" "Yes, yes, yes, yes." Okay. Then I read the reports to the jury, and I should say, knowing what I was going to do, I spent quite a bit of time with the jury opening to explain to them that defamatory statements are presumed to be false, and that they have to know that, otherwise I'm painting a very bad picture of my client with the jury. And it took me about 15 minutes, 20 minutes, and Mr. Walker got up and moved for non-suit. And 5 minutes later, the case was dismissed. And the judge held, really, I just proved that my client was a bad man. He didn't know very much about libel, with respect, but also I hadn't proved publication. And I couldn't believe what happened. Horace Screever and I got back to the motel at 3:30. We were on way back home about an hour and a half after we started, which was a very sad day. Anyway, we appealed the case to the Court of Appeal, and much to my chagrin, we lost 2-1. They held that we had not proved publication. We proved that a request had been made and that there had been a sent, but we didn't call the person to whom the publication is supposed to be made. And in those days, our Court of Appeal liked a little book called Button on libel and slander, Gatley's very big book, and it was very convenient to refer to Button. And no doubt in Button, there's a passage that says it's essential in a libel case to prove publication. And you got to prove you had to call the person to whom the publication was made, except of course the newspaper, which is presumed published by the Libel Slander Act. But Gatley had a different version of what the situation was. And we finally got Supreme Court of Canada, and their justice triumphed, and I began to breathe easy again. And the court held that we had produced evidence from which the jury could infer that the publication, that the material had been in fact published. I'm not sure that I would try that again. But the point also is that the court in the Supreme Court of Canada made clear that if you call no evidence and move to dismiss an action and you lose in the appellate court, you may be deprived of calling evidence again in a second trial. In that case, they gave the defendant the right to do that because of the unusual nature of the case. Now, also, these cases are, as I say, highly emotional and often acrimonious. And it's the one case where conduct of defense counsel can be both evidence of malice and evidence of aggravating damages. It's quite clear, apart from Hill and Scientology, which merely adopted the law, and you get it in Gatley as well, that the conduct of the defendant from the time the libel is published, after the libel is published, and at a trial, is relevant on the issue of malice and relevant issue of damages. And the defendant cannot hide behind the role of counsel. If counsel conducts himself or herself in a manner which you can infer malice, or conducts itself in a manner which would aggravate damages, the client is stuck with it. Thus, in a case where you're defending, you don't plead justification, you try to impute bad character to the plaintiff, you're in trouble. If you seek to find other grounds to disparage his character, if you seek other grounds to support something which you're not justified, then that all goes to question of damages. Now, I've spoken about the fact that these cases are sometimes acrimonious, and the other difficult experience I had was with a lawyer called Nella Starr. I don't want you to think I'm a hard person to get along with, but like two people really gave me a lot of trouble with David Walker and Nella Starr. And Nella Starr and I had a case called Dalrymple and Sun Life. By the way, the Gaskin case and Dalrymple is both reported. It's the only case that went to Supreme Court of Canada twice that I was on. It was a case involving Mr. Dalrymple, who was a branch manager of Sun Life Insurance Company in Peterborough. He'd have difficulty with Sun Life over the years, and one time phoned up and said he's leaving, and most of the agents are going to quit with him. So the general manager in Toronto phoned up the assistant manager in Peterborough and said, we're coming down, hold the fort, and Mr. Dalrymple is not to issue any checks till we get there. It was on the basis of that statement that the action was founded. I won't go into details of the matter, but in the action, Mr. Starr, every time I'd ask a question, would say, "Your Lordship, I want you to note Mr. Dubin's attitude in this case. It's evidence of malice." And I thought I was behaving quite nicely. But everything I said, he says evidence of malice. I want you to record, make a note of it. And anyway, at the end of the trial, I moved for a directed verdict or for taking the case away from the jury on the ground. It was an occasion of qualified privilege and no evidence of malice to go to the jury, and succeeded. Mr. Starr appealed and won the court appeal, and also in Supreme Court of Canada on the ground there was some evidence to go to the jury of malice. It went back before Mr. Justice Brooke, but going back on that case, Mr. Justice Spence, who wrote the judgments of the Supreme Court of Canada, commented on the fact that the trial had been very acrimonious between Mr. Starr and myself, but my conduct was sufficient enough to found an action of malice, which I sort of got saved a bit by that. Now, I want to tell one other case. I just want to bring this case to Trish Jackson's attention. Some years ago, I got called by a lawyer called Peter Newcomb in Ottawa, and he had called me just after he recovered from his faint. He was a case called Natuski and Craig and Kohler, which is in your material, and the jury had awarded $250,000 damages, general damages, and he That's, I think, the largest award at that time. Peter was defending. He fainted when the jury came in, woke up and called me to ask if I'd take the appeal, which we did. But I commend that case to you because I think it's got the best explanation of qualified privilege in a case called Taylor Despard. Mr. Justice Schrader wrote a very thorough judgment on qualified privilege. And also with respect to something you said earlier, it was clear in that case that on occasion of qualified privilege, there's presumption of good faith and absence of malice. You don't have to prove the good faith if you have qualified privilege occasion. Also, it's a very important case on the question of an innuendo as well. Well, I think it's almost 5 o'clock, and I'm going to let you all go and have a nice weekend. I just want to say something about role of counsel in a court of appeal and at trial. I think what we look for is sincerity. That, I think, is the most important attribute. You can't be sincere unless you're yourself. As Sinatra said, you got to do it your way. If you mimic somebody else's style, you're not sincere. Also, you're entitled to be firm. I don't like obsequious counsel. You can be firm, but you can be courteous at the same time. And in any jury case, as Bob Armstrong said, it's not because you're flattering the judge or jury, but nobody wants to see anybody unnecessarily insulted. And there's nothing like a courtesy to carry the day. As I say, you can be firm, but you can be courteous. But particularly, I think, in libel and slander actions and all jury actions, the concentration is on the jury, is on the lawyer. And near the end of the case, when you're standing addressing the jury, all eyes upon you are on you. And you've got to, I think, to try to get the jury to try to help you. You need their help. You've presented your case, you're convinced upon its validity, and you need their help. You do that, I think, now in a quiet, persuasive manner. The old days of strong oratory, I think, are gone. What I think jury is looking for, as I say, are calm, dispassionate persuasion, with some sincerity, and I think sometimes a feeling of they want to like you, they want to help you succeed. And I want all of you as well to succeed. I'm very proud of our profession in this province. I'm very proud of our court and our justice system. I want to again congratulate all of you for this very interesting program, and thank you very much for allowing me to be part of it. Thank you.
Thanks, everybody, for coming, and that was a very enjoyable day, and I want to thank all the speakers again. Thank you.